A trial in a law court is not just a match between two lawyers. This is also important. Lawyers also should realize that their success is on account of the inherent strength or weakness. I mean, their failure also is due to the inherent weakness of their clients' cases. Their job is to skillfully identify and polish the case, as if just as a diamond cutter and polisher, he polishes a true diamond so that it will shine. So only the lawyers with good professional competence can do that. Competence can do that. The success rate of some lawyers might be high as they filter out bad cases at the threshold and accumulate only good briefs. What's wrong with this? This is important. In my book, Lawyers, Glorified Priests or Empowered Judges, which is available as a Kindle edition online, I have explained these notions. The Honorable Mr. Justice M.N. Venkatachalaiah, former Chief Justice of India, was gracious enough to write the foreword to my book. I am only extracting some portions of it to tell my audience that he also approved my rather unconventional notions. Here are the extracts from the foreword that he contributed. Quote, Sri Desai's first observation is that an increase in the judge's strength, though necessary, by itself is no assurance of quicker justice without a supplementary supporting procedural discipline. Sri Desai argues a system of private sector judges and observes, though there is a shortage of judges, quantitatively viewing, there is no dearth of lawyers in this country at the current level of litigation. Under ideal conditions, all diligent lawyers are meant to act as judges of the private sector only when there is predictability in judgments. It is the public as consumers who pay for their services without burdening the exchequer. If the subordinate judiciary in particular and the judiciary in general is predominantly predictable, diligent advocates can correctly advise their clients to enable them to arrive at settlements before trial. Only in a small percentage of cases, when the judges of the private sector are unable to come to a consensus, the state appointed judges step in to formally decide the dispute and give finality to it by acting as referees. In the US, the state appointed judges give formal judgments only in 2% of the cases, both civil and criminal. A vast majority of the cases are settled by the parties themselves on the basis of the concurring legal opinions. In other words, concurring judgments of lawyers on both the sides. Unquote. Sri Desai speaks of the imperative of predictability and consistency in judicial outcomes and says it requires conscious human effort of lawyers and judges to make the judiciary predictable so that the citizenry can plan their transactions to avoid litigation and to win the cases when litigation is thrust upon them by the wrongdoers. Unfortunately, due to lack of predictability and consistency in judgments, we in India continue to visualize lawyers as priests in a temple who recite incantations before gods, that too man-made gods called judges, and anxiously look to them to deliver either a boon or a curse. The appellate courts may reverse their judgments, but no punishment is being given to the wrongdoer as he is a judge. Though doctors, engineers, even lawyers and accountants could be hauled up in consumer courts or even criminal courts for their wrongdoing. The priests and the man-made gods of the justice delivery system have conveniently converted the litigants into devotees instead of according them their due and true status as consumers. Unquote. Sri Desai also comments some additional inputs to the Judicial Standards and Accountability Bill 2012 and says that accountability must also include an omission on the part of a judge to respect and follow a binding judicial precedent. If he fails to do so, he should be held guilty of misconduct and dereliction of duty. There are many other useful suggestions in Mr. Desai's agenda for speedy justice. I congratulate Sri Desai for the refreshing thought he has bestowed on a topic which has become banal, that is boring, by stereotyped approach so far. The public cynicism that loss delays have engendered might assume destructive proportions. Cynicism is a destructive emotion. Unquote. Now, this is how the former Chief Justice of India also has been impressed by these unconventional views. Law is predominantly like a railway track and not just a guideline. The mandatory provisions and binding precedents which interpret the law, forming the flesh and blood around the skeleton, are similar to railway tracks to bind the judicial train to travel only on the track. A lawyer, in his capacity